I would like to read part of a statement from Ian Pace, who is a lawyer working for Countess of Chester. I agreed with the Trust's decision to keep Letby away from the NNU pending the outcome of the further forensic review, which was in line with the advice that Corinne Slingo. She is partner, head of healthcare regulatory, so she's very high up. Corinne and I had provided previously. Based on the information I had received, I understood that the 2 external reviews had not provided any evidence to suggest that Letby had been involved. Instead, I was instructed that the reports advised a systemic failing on the neonatal unit. Whilst that was the case, it remained my view that Letby should not be allowed to return to the NNU until those investigations were completed. Letby continued to be redeployed to an administrative office-based role, and I understood that she did not have access to medical records for the NNU, in line with my advice that Corinne had provided previously. Based on my instructions as to what the Trust knew at that time, that the external reviews did not provide any evidence to link her involvement, the Trust's decision to continue to redeploy Letby away from the NNU did not cause concern, and it achieved the same objective as suspension would have achieved, to ensure that the integrity of the investigation and patient safety continued to be protected. The attendance note refers to the possibility that Letby may be placed at risk even if there was no evidence found as part of a forensic review. I anticipated that even if the forensic review did not reveal any evidence of her involvement, it may still be very difficult to reintegrate her back into the NNU, which was being suggested as a potential outcome at the time. Corinne was aware of Letby's continued redeployment and was continuing to advise the Trust in relation to the ongoing investigations. I would have expected Corinne to advise the Trust if there was a requirement to refer Letby to the police or other external regulator, which fell within her specialist area rather than mine. From my perspective, I considered it prudent to keep her redeployed while there remained any form of investigation. That made sense as a matter of patient safety, because there remained a sufficient concern for the Trust to continue with its investigations. However, with each investigation coming up clear, this would seem to point against making an external referral, although that was an issue for Corinne to advise the Trust in relation to. I note from the attendance note that I received a call from Sue Hodkinson on the 18th of November 2016. I might go and have a look at that in a sec. The attendance note records that Letby was fully engaged and not taken any sick days. She explained that the external and internal reviews had all been completed and there was nothing to implicate Letby in any of the events. Sue explained that based on the lack of evidence to implicate Letby in the reviews that had been undertaken at that point, the board had decided to return Letby to the NNU, and the Trust had already started taking steps to reintegrate her. It would have been my understanding at the time that Corinne was continuing to advise the Trust in relation to those investigations and would therefore also been made aware of the findings. During my previous call with Sue on the 28th of October 2016, I expressed concerns about the possibility of Letby returning to the NNU because at the time the second forensic review was still pending. Based on the information provided by Sue during this telephone call, it was my understanding that the second forensic review had been completed and an internal investigation, and neither had revealed any evidence of Letby's involvement, and no further recommendations had been made for further reviews to be undertaken. At the time, despite the several clinical reviews that had been undertaken, there was no evidence to implicate Letby, and objectively no reason to support her continued redeployment. Her redeployment being she was placed in an administrative role. Based on the information that the Trust had in its possession at the time, from an employment law perspective, I expect that the Trust would have struggled to justify her continued redeployment away from the NNU without any evidence to implicate her. And just quickly on this, note that Ian Pace, the lawyer, made on a phone call from Sue. Talking about Letby, she still may resign and claim constructive dismissal because we have excluded her from her duty. This type of claim will be capped unless she can show there is a whistleblowing element to it, in which case exposure would be unlimited. I said that overall, bearing in mind her salary, the financial exposure isn't all too great for a constructive unfair dismissal only claim. On balance, the Trust would rather this than potential patient safety issues and the reputation impact this would have. So, lawyers being lawyers and hospitals being like a business, all they care about is the functioning of the hospital. If they have to lose a nurse, so be it. And what they're worried about here is that they've actually got from an employment law perspective, the lawyers for the hospital have no justification to continue her redeployment, even from an employment law perspective. Now, isn't it ironic that they can't even justify it? They're saying that Letby would have a case for constructive criticism, a case for constructive dismissal, and they couldn't justify her being even redeployed into an admin role, yet somehow the Cheshire Police have managed to spring murder charges on her, and yet the hospital couldn't even justify moving her from an employment law perspective. Just let that sink in for a minute.